Hello, good afternoon, everyone. It's good to see you. I am Angie Vosing, president of PACO, and today is Thursday, May the 16th, 2024. We are here for the Workers' Comp Roundtable. We'll go ahead and get started. It is like a minute after noon, so we'll go ahead and rip right into this. Today, we are so pleased to have with us Attorney Sue Raudebush. She is with Taft, and she is going to be presenting to us today on the topic of VSSRs. Sue's practice, she practices employment law, focusing on workers' comp and OSHA law and procedure. She represents self-insured and state-funded employers during all stages of their workers' comp matters, including claims investigation and management, administrative hearings, litigation, appeals on mandamus before the Court of Appeals and the Supreme Court of Ohio, and settlement. In addition to being in private practice for several years now, Sue also worked as an assistant Ohio Attorney General in the workers' comp section. She regularly writes and presents on workers' comp and OSHA topics. And I am absolutely certain that she is eminently qualified and she is going to share her knowledge and expertise with us today. Thank you so much for being with us, Sue.
Thanks, Angela. I just wanted to note, I do see we had talked before about the attendance list, and Michael, hello, how are you? It's good to see you on here, and if you want to chime in at any time, feel free. Heather and Angela, Michael is a former BWC investigator. He has his own consulting company at this point. So again, feel free to jump in at any time. Heather, if I can put you on the spot for a minute, what is your position? Are you a paralegal with an employer's firm, a claimant's firm, just so that we can help tailor this to everyone's needs?
I'm a paralegal here at Porter Wright, so
Okay.
employer.
Okay, sounds good. I think you're right downstairs then.
Yep.
All right.
And Michael, thank you for hopping on and joining us today. It will be interesting to hear your perspective as well. What I will do is I will monitor the chat. If there are questions, feel free to jump in, feel free to put your questions in the chat, and then I will bring those questions to Sue.
Okay, sounds good. I'm going to go off screen here so that you guys are not, so that you can pay attention to the video or the presentation, and we'll get started. So, okay, thank you for joining me here today. We have a lot of information to cover, so I'm going to jump right in. But as Angela noted, feel free to unmute or populate the chat with questions. Since it is just a few of us, we have the benefit of really meeting your needs however we need to here. So, all right, so the first thing to know is that VSSR is not OSHA. And this is really an important point, and it's one of the reasons that I started doing these presentations on VSSR is because a lot of times I would get to the employer, meet them for the first time, you know, once a VSSR has been filed, and they say, we're fine, we're compliant with OSHA. And, you know, our OSHA consultant was here a few months ago, and we should be fine on this. And you know what I share with them is that, again, VSSR is not OSHA. While a lot of the standards are the same, some of them are not, but also what a VSSR investigator is looking for is not the same as what an OSHA investigator is looking for. So the preparation is different, and we just want to get the word out to employers and everyone who helps them, you know, paralegals, attorneys, consultants, you know, as far as, you know, what they need and how they can best prepare well ahead to protect themselves. So what is a VSSR? Oh, sorry, got button happy there. To understand a VSSR, it's important to start back at the beginning with a reminder that the general purpose of Ohio workers' compensation system is to provide statutory benefits to compensate employees for work-related injuries or diseases. And the payment of benefits is tied directly to medical costs and indemnification for lost work time. But because workers' comp in Ohio is a no-fault system, questions as to how or why an employee was injured usually are irrelevant for the most part, as far as other, beyond the mechanism of injury when you're looking at the claim originally, except for a VSSR. That's when we look into fault. You know, could the employer have prevented this? What was the employee independently negligent? You know, those are some of the things we're going to talk about here today. But that's really, you know, when we are talking about VSSR, it's important to understand exactly, you know, why this is different than the underlying claim. So violation of specific safety requirement is what VSSR stands for. It is a fault-based penalty assessed against an employer in addition to the underlying claim for an unsafe practice that proximately caused an injury. The VSSR is grounded in the Ohio Constitution, Article 2, Section 35. It says, in addition to an underlying workers' compensation claim, the Ohio Constitution provides for an additional award paid by the employer to the injured worker where the employer committed a violation of a specific safety requirement. The relevant laws here are ORC 412137, creation of the Division of Safety of Hygiene, and then OAC 41231, Division of Safety and Hygiene. And then we'll get to the grandfather clause here in a moment. Heather and Michael, the 41231 is really what you're going to be focusing on. That 412137 is just the creation of it. It just gives the Ohio the power in the Division of Safety to be able to implement VSSRs. When you're looking at your code sections, you want to look in chapter 4123:1.
And Sue, before we get too far down the rabbit hole, I am interested, we actually have a couple of VSSRs that we are defending currently where the employee involved is actually a contracted, an employee of a contracted firm doing business on the grounds of the employer. And so we're dealing with issues of, you know, who's liable, who's, you know, the employer and things of that nature. So if things like that come to you as you're presenting and you want to share any insights on those kind of cases, that would be really helpful.
Absolutely, yes.
Thank you.
I'm looking through real quick to see if we have some of the defenses that pay attention to that, but just real quick before we move on, knowing that you're dealing with probably some independent contractors, staffing agencies is what I'm hearing you say, is that independent contractors are going to fall outside of workers' comp. They shouldn't say that. That's actually wrong. They don't fall outside of workers' comp. They should have their own workers' comp. So they would be responsible for their own safety unless the contractor, I'm talking in construction, is responsible for the manner and means or provides the equipment. You get into those kind of issues, and then you get into the issue of whether they really were an independent contractor at all. So that the actual term independent contractor gets a little iffy and a little bit messy when it comes to VSSR. But if you're dealing with a staffing agency where the staffing agency is your client and they have member clients, so they, let's say ABC Staffing, provides employees to XYZ employer. XYZ employer is the employer for VSSR purposes, but ABC Staffing would be the employer for the underlying claim. And the reason for that is just contractual for why ABC is responsible. They pay the payroll of those employees, for lack of a better term. But then whenever they are at the member or the client customer employer, i.e. the XYZ employer, then that XYZ employer controls the manner, means, methods, provides the training, those kind of things. So that they are responsible. Does that, in terms of just a background?
That we have had one with a staffing agency in the past. That is long done. The two that we're working on right now, the employee of our client was injured because of the actions of a company that was contracted to provide services on
Okay,
their campus.
okay.
So that's the situation specifically that we're dealing with. Michael, it looks like you have a question or a comment that you would like to add.
Michael, you're still muted, but good to see you.
Okay, can you hear me now?
Yes.
I can hear you. Yes.
Okay, yeah, and I've had over the years, many cases specifically within the construction area of VSSRs where you may have a general contractor and then you have multiple subcontractors, and then you may even have subs of subcontractors. And so those tend to kind of be difficult because as a general rule, we always look for the employer of control
Mhm.
who sets the hours, who basically controls every aspect of what's going on. Some of the general contractors that we've worked with in the past, uh, when they have projects, and particularly large projects, they will have in their contract with subs that they have to attend and certify in certain things that the general, as far as their safety, requires overall. So that means they would have to attend all the safety meetings that all the general employees would have to, and they would have to meet certain criteria, such as equipment operation. They would have to have that, the general contractor would have to have that on record so that they know that the people that are operating certain equipment are certified and qualified. Because you get into a thing where a person may have operated said equipment, let's say such as a front end loader, but operating a front end loader at one site is different as going to another site. And so they may have certain requirements and elements that that person has to meet before they may be qualified, but they may not be authorized until they go through the general contractor's specific program designated for that site.
Right, and just to kind of chime in, Angela, you're still going to be looking at the 4123:1. All of the subchapters are the same. They apply to all of the same employers. So if they're looking at whether an employer, subcontractor, subcontractor, any of those kind of things are going to be liable, they're going to funnel it down from that general down into who's actually liable, and
Right.
then still apply the 4123:1.
Okay, thank you.
Yep. All right. And I stopped my video just so that I can see my slides, so I do apologize. But I go. So the grandfather clause, before we move on, some claims are governed by older codes, and that's based on the date of installation of the machinery or some other factors. And so that's when this grandfather clause comes in. And so I just want you to be aware of it, that if you are dealing with older machinery or older systems, that you could be looking at a older code section. And so some of the advancements that may have come along and are being alleged were required may not have been required at the time when the based on the date of installation of the machinery. So those are some defenses as well. But I throw out that grandfather clause just so that you're aware of it as relevant VSSR laws. All right, so the reason this matters is, and I like to put this up front, is that the penalty of a VSSR is 15 to 50% of all indemnity paid in the claim. This is paid at the maximum rate for the injury year, and it's paid out of pocket by the employer to the injured worker or their dependents. It's outside of the workers' comp but there is still an impact to the EM or the EMR. And so EM and EMR is not exactly something we always deal with in workers' comp. We handle the claims, and it goes back to the employer. We look at things through the TPA lens, but the EM, EMR is really impactful to construction in certain industries, and it allows them to get contracts. The better their EM, their EMR, the
Right.
more likely they are to get those contracts. So that's where, the outside factors of thinking like your client is how is this going to impact my EM, ER? At the end of the day, the money matters, don't get me wrong, but they are really looking at that safety EM, EMR. All right, so what happens if you have more than one VSSR? If a company has 2 violations in 24 months, the Industrial Commission can impose an additional penalty of up to $50,000. And so when we look at this in an example, we can look at, a 2012 injury amputation. This is purely made up, just as a heads up. Amputation of right arm, you've got a psychological condition. The person has gotten temporary total of $84,136. Large permanent partial award. It's 225 weeks. I believe that's for amputation of 2 arms, quite honestly, but again, just a quick example just to say how things can go. PTD, if they're looking at PTD for 30 years, 1.2 million. The VSSR range, that 15 to 50%, is $229,230 to $764,100. So that's a huge range, and it's paid out of pocket. Now, most employers do not have that just sitting around. I mean, sure, do they have contingencies? Do they have insurance? Yes, but most employers don't have that just sitting around. But when you add on an additional penalty, it's another $50,000. So these are some serious numbers that we're looking at. And when we circle back around to that original slide of when I show up to an employer's place of business and they say, oh, we're okay because we complied with OSHA, it's 2 different things. And so I was learning that smaller employers don't necessarily know a whole lot about VSSR until they're tagged with one. A lot of the larger employers do, but it was really these small employers that cannot handle a VSSR impact of $229,000 to $764,000. I mean, it will bankrupt them. And so this is really what, again, started my soapbox, for lack of better words, and why I started presenting on VSSR at different places. So what does this mean for the employers? What it means is VSSRs are a big deal. And so that's what we need to get across. This is not OSHA where the penalties are defined. This is VSSRs coming out of pocket that if you continue to have VSSRs, you're going to continue to have injuries, and you're going to continue to I don't want to say upset the BWC, and they may look at whether you're even whether it's even safe for you to operate in Ohio. That is a very long-term, unlikely result. Most people get it before it gets to that point, but that is, obviously what can happen. So who's at risk? These are the 9 chapters within that OAC code, and these are the industries that are at risk. Elevators, if you have an elevator, think about that. Construction, workshops and factories, metal casting, steel making, manufacturing and fabricating, laundering and dry cleaning, rubber and plastic industries, window cleaning, and firefighting. So if you have a client that is in one of these industries, you should be educating them on the possibility of a VSSR and how to best protect themselves should they be involved in one. So if you already know that, and I can honestly say, Angela and Heather, I know that you both have clients in these industries. I'm familiar with some of your clients. So, this is just the right place to start as far as how to get more involved. Something I know that I did previously, just as a way to help your clients, was that in my last firm, my paralegal and I worked, and we put together monthly we put together monthly articles on VSSR chapters, you know, not, you know, the boring stuff, but the practical stuff. And we would send it out to our clients and say, you know, hey, you know, here's how to just become aware. So that might be something that, you know, if you guys are up to it, you know, and helping your attorneys, I know that they would appreciate it, and your clients will absolutely appreciate it too. So just something to think about if you have clients, you know, in the window cleaning business, and, you know, maybe they haven't seen a VSSR yet, which is great, quite honestly, but if they do, you're going to want to talk to them about, you know, how to best protect themselves. So each subsection equals one potential violation as well. So when we talked about the chapters, we said that each chapter has an industry, and then there's subsections within each of those chapters as well. And so each one, when you, and I know Angela and Michael and Heather, you're familiar with these, you've got the A1, AB, you know, all of those subsections. The A1 can be one violation, A1A can be another violation, A1B can be another violation. So they can really stack up is really what it comes down to. So even what we see a lot of times are complaints that just generally file, hey, I want, you know, 4123 :1-5 13. And then you've got a lot of subsections under there. And so each one could be a potential violation, so that when your attorneys are at hearing, they're defending against possibly, you know, let's say like 35 violations. And if one sticks, you still have a violation of a VSSR. So it's not all 35 have to stick. It's that one that, you know, just one of them needs to stick. And so that's something to think about when you're looking at each one. Yes, they compound, but they're very different. And, you know, we're going to get to the defenses here in a moment, but it's just to show that how extreme these can be. It is all the same penalty. So if either 1 or 35 are violated, it's the same penalty regardless, you know, but it's still the idea that even though you might be good on 34 of them, if there's still one, it's still a problem. So the next thing I want to draw your attention to is we talked about the chapters. The one chapter, 4123:1-5 is workshops and factories. This is not just manufacturing. A lot of people, you know, when they start into VSSR, think workshop and a factory of, you know, have to stand alone on their own, and it's, you know, and that's where it falls in. That is not the case. Case law has expanded workshops and factories to be outdoor areas if they are fenced in, and they will also look at workshops or a factory within another building. So let's say you have, you know, for me, I represent some school districts. They have workshops within their, one has an auto place, another one has a, oh, I can see the presses, but I can't think of the name. It's just slipping my mind. Shop class, you know, so those types of things are considered workshops. So you think about them in employers, you know, or manufacturers only, but you're really looking at them as what looks like a workshop. It's not necessarily that they're being paid by a specific customer. You know, there are these smaller workshops within entities that you don't even think of being, you know, relevant for workers' comp. Not for workers' comp, for VSSR. So the workshops and factories, we see that filed a lot, and sometimes it falls within it, sometimes it doesn't. But if you see a workshop and factory code, I would recommend that you do some research and see whether it's going to include your client or not. All right, and so I always include, if you know me, you know you get pictures of my dogs in all of my presentations, and I felt like I bored you enough with some of that background information that you got a picture of my dog. She's my oldest. She's roughly 12, 13. We're not real sure. She was rescued, but so hopefully you're all smiling. All right, so how to defend against an VSSR. And this is, you know, again, I don't know, for me, I have taken my paralegals on the investigations at times. I've taken them to the hearings. I don't know, Heather and Angela, whether you have done that, you know, but for me, it's important that they see what I see so that they are helping is, you know, behind the scenes as much too. You know, if you don't know where you know, what the hearing looks like or what the investigation looks like, you don't even know how to help defend, you know, not that you don't know how, but it's helpful to, with the defense of those. So Oh, sorry, had a little glitch there. So how to defend against a VSSR. For a successful VSSR, an injured worker must prove all of the following. So all 4 of these must be proven: that the specific safety requirement cited is applicable to the situation. So again, we're looking at, did they cite a workshop and factory? If you don't have a workshop and factory, it's not applicable to the situation. The employer violated the specific safety requirement. And so they actually have had to violate it, but it's going to be these next points. It's not just that it negligently happened. They have to have known about it and violated it. And so much that the injury sustained by the injured worker was the type of injury designed to be prevented by the specific safety requirement, and that the claimant was injured as a direct and proximate result of the violation. So if you're looking at an injury where you have a lockout, tag out situation, but the person actually slipped on their way to, perform the lockout, tag out duties, the lockout, tag out is irrelevant. They actually slipped on something else. So the lockout, tag out is not the direct and proximate, cause of the injury. The slipping on, let's say, some oil or something like that is the direct and proximate cause of the injury. So you need to, you'll see a lot of the code sections just filed on that application just to see if they stick. And so that's why, this last part is the direct and proximate cause issue. A lot of claimants will just, again, write a general chapter or section and see what sticks out there. But you've got to go through these 4 factors, and we're going to break them down a little bit more as we go through the specific defenses. But these are the buzzwords and what your attorneys are arguing at those merit hearings. In other words, a claimant must prove that his or her injury resulted from the employer's failure to comply with a specific safety requirement. So that's the breakdown. It's a much easier breakdown of those 4 elements, but again, the attorney has to go through those 4 elements. So unless it was the employer's failure to comply, you don't have a VSSR. Okay? I shouldn't say that. You don't have a violation of a specific safety requirement. So this is all about the employer's fault. Employer defenses, we've got legal defenses and we've got meritorious defenses. The legal defenses are whether it was timely, whether an inapplicable code section was cited, and like I just said about the lockout, tag out, that's, or the slips and falls, that could be that one. Undefined or vague definition. Angela, your firm has a very good example of this, and it's actually the example I use in my presentations, and I don't put the case name in, but it's about expanding the definition of a operator. It was a couple years ago. I don't know how long you've been with them, but it was a VSSR. It went up the whole ways to the Supreme Court. And I worked with the Ohio Manufacturing Association at the time. And your client and I think it was Mr. Conkle asked the OMA to get involved, and the OMA didn't get involved. And I think that was a mistake on their part, in my opinion, because it certainly affects all manufacturers of who the operator is. And so there was, it was an unfortunate a decision against the employer. And I really do wish that they had gotten involved, and it just showed like the ramifications of it, broadly versus just your specific case. But yeah, it was a very interesting case. And once I remember the name of it, I'll let you know. But so on the merits, this is where you go back to those 4 factors. The violation was not the proximate cause of the injury. The employer complied with the code. If there's compliance, there's no violation. Unilateral negligence, which is negligence of the employee. Single occasion failure. This goes back to MTD products, which talks about, you kind of get one chance for, equipment to fail. If you didn't know, you didn't know. Authority to alter or correct. If you've got some, let's say, some machinery in your factory or some overhead conveyors, and a company has come in and installed those, you don't have the authority to unilaterally change those. The company that maintains them has the authority to do that. So could the employer alter it to make it safer? Not if it's not required by the guidelines and the company hasn't recommended that. So you have to look at that, as a defense as well. Also, impossibility. Was there a way that the employer could have prevented these injuries? Let's go through each one. Was the application filed within 1 year from the date of injury? And that's ORC 4121.471. It used to be 2 years up until I think about 3 years ago. It was filed, it was 2 years from the date of injury. By that time, you would have witnesses that would leave. You would have materials that had been changed out, machinery that had been changed out, or documentation that just wasn't saved properly, and so this was really difficult 2 years after a injury occurred for an employer to go back and defend themselves, because really what you're looking at is it's filed 2 years. A VSSR takes about 9-10 months to get the entire way through the process with the investigation and through the merit hearing. So now you're at 3 years really from the date of injury. So the business organizations got together and asked the Industrial Commission to change this, and they did. They changed it to 1 year. So now there used to be a time when you were in that 2 year, 1 year. We're beyond that at this point. So now it is just 1 year from the date of injury for all claims. The next defense, as I noted, inapplicable code sections cited. The machine or situation in question is one that is covered by the code section. The code section was violated, and that the violation was the proximate cause of the injury. This is your defense, and that comes under LTV Steel. So if you need to look that up for one of your cases, this is where you would, or one of your claims, this is where you would look that up at. But again, that's where I noted that, if they're talking about, if they're talking about a certain type of saw, you'll see when you're talking about handheld saws, there's circular saws, there's rotary saws, there's different types. And so if the claimant cites a rotary saw section, but it wasn't, it was a different type of saw, then that code section doesn't apply, and that's your defense. There was no violation of it because there was no obligation for the employer to comply because it wasn't the right machinery. So you kind of work back through that 3, 2, 1 whenever you have the machine or situation in question is not one that's covered by a code section. Does that make sense to everyone? Is there any questions on that one? Okay. All right, undefined or vague definition. Again, this is, I don't think this Borden case is the one that I was talking about with you, Angela, but this is where the OAC does not define the relevant equipment, machine, or device, and a cited provision refers to equipment that is not part of the machine in question. It is improper to apply that requirement to the employer. So let's say that we were talking about overhead conveyors just a minute ago. I had a case that had this. The overhead conveyors did not require, the manufacturer of the conveyor system did not require, because they are so high up off the ground, to have guarding on top. And someone was working on the conveyor and they, for whatever reason, climbed across it and fell in. And so this was not a lockout, tag out situation. These conveyors were not connected. They did everything properly as to the conveyor that was being worked on. But again, for unknown reasons, this person climbed across a conveyor. And so the big question came, well, you should have had guards on those conveyors. No, the manufacturer, all of the, not the consulting companies, but anyone that came in and updated that machinery, there was no requirement for guards because you were 40 feet off the ground, and the catwalks were 14 feet from the conveyors. It was highly unlikely that someone was going to climb up and over. Did it happen? Yes, but it's not a it was not required to be part of the machine in question. So that's your defense of, the employer, as the machine in question stands, did everything it was required to do. And that's the defense of, this was undefined or vague. The equipment that caused the injury is not part of the machine in question. So compliance with the code, this one's a simple one. No violation, no VSSR. If they complied with the code, if they provided fall protection to the specific heights that they were supposed to, and a fall happened anyways, and there was an injury, there was no violation, no VSSR. So the employer did everything that they needed to do. They trained the person, they provided the equipment, there's no violation. Not the proximate cause. The machine or situation in question is one that is covered by the code section. The code section was violated, and the violation was the proximate cause of the injury. So that's how one would find a violation for proximate cause. So, and that's what happened under LTV Steel. But your argument is if you can take out any of these, any of these pieces, so say the machine or situation in question is one that is covered by the code section. If it's not covered, it's not the proximate cause. And you can take out any of these pieces. So again, when you're looking at that lockout tagout situation, he was on his way to lockout tagout, but he slipped on some oil. A lockout tagout was not the violation. The slipping on the oil, maybe not having a wet floor sign out, was the violation. But if the claimant cites lockout tagout in their application, that was not the proximate cause of the injury. Unilateral negligence. Unilateral negligence on the part of the employee is a defense to a VSSR. However, there must be no negligence and no fault on the part of the employer for the unilateral negligence defense to prevail. So we were talking about that conveyor situation. So again, the employer did everything that they needed to. They followed all of the instructions from the installer, the manufacturer. They locked out, tagged out the other conveyor. This person chose, again, for whatever reason, this is actually one of my cases it's done with now, but again, the person chose to climb up a catwalk and over a conveyor that was not shut down, that was not being worked out. We really don't know whether he believed it was a better vantage point. He was actually supposed to just be helping the maintenance person. He should have just been standing next to the maintenance person. And for whatever reason, he wasn't. And so when we looked at everything, it wasn't enough that we just said, hey, this person climbed up over and we don't know why. We also had to show that there was no negligence and no fault on the employer for the unilateral negligence. We had to look at, hey, other employee, did you suggest that he, climb up over there? Were there guards and we didn't put them on? Even though that conveyor system wasn't the one at issue, should there have been a guard on that? No, so it was those kind of things. So this one is two-part. You can't just point the finger and say, haha, employee, you didn't follow directions. The employer still has to follow directions as well. Single occasion failure. There's no violation if employee was injured as a result of a single one-time event and the employer had no knowledge of the defective condition. And so the case that I think of here is a Shelley and Sands case, and it's about 20 years old at this point, but the dump truck on the highway, they had come out that morning and they were starting their work that day, and they did not do a walk around of their truck. They did not check the sensors. And so someone, when the truck was backing up, the sensor there was no backup alarm. And so someone was crushed, unfortunately. And so they didn't know that there was a defective condition. They did not know. And the injury, the employee was injured as a result of the single one-time event. But they could have had knowledge, is what the court held. They could have had knowledge had they done their walk around. So the employer has to be completely absent of the possibility of a defective condition as well. So it's not enough that they had no knowledge. You can't blindly put yourself in that spot and say, well, we didn't do our walk around, so we didn't know that the backup alarm wasn't working. You have to have done everything right still. and then had no knowledge. So if they had done their walk around and the sensor was working and they were, 2 hours into their construction project and somehow that sensor stopped working, then you would have this defense. But you can't just put yourself in a blind spot and claim no knowledge. You have to be able to say, we did everything right still, and therefore we had no knowledge and it was a true accident. Authority to alter or correct. The employer must have the authority to alter or correct a VSSR violation in order to be held liable for it. We talked about the installation of, the catwalk and things, but this also goes to the staffing agency, the independent contractors, the subcontractors, those situations. If a general, unless it is in their contract that they are liable for responsible for training or safety or something like that, they're most likely going to be out of the VSSR. It's going to be those subcontractors that are responsible. But again, that's a contract issue. Staffing agencies, that again is the staffing agency places the employee. It's up to the company or the customer company to make sure that that person is trained properly. As Michael pointed out before, you can't just move someone saying, the staffing agency places someone with the specific understanding that they have X, Y, and Z knowledge. You can't change their position while they're there and say, okay, now they have to have P knowledge too, and they don't have that P knowledge, so this is the staffing company still doesn't have the authority or alter to correct. So generally a staffing agency is not going to be held liable for that simple reason, but you need to look at who was all involved. If there is an interim training company, did they provide somebody that had X, Y, and Z training capabilities, and then the customer employer changed their job without talking to the interim company? So there's lots of different factors here. Again, 99% of the time in a staffing agency situation, you are going to have the staffing agency out. But there's the 1% chance that they could be drawn back in because maybe they're responsible for training or providing somebody that has that training.
Okay, what are your thoughts on a situation where a company knows that, where there's supposed to be a guard on this machine, but we don't have the authority to alter the machine. So they call the manufacturer or whoever is responsible for maintaining it, and they come out and say, yeah, you've got to have a guard there. It'll cost you 25 grand to have us put it on there. And the company says, yeah, we're not going to pay 25 grand when we've got a guy that's really good with the welder over here, and we're going to put our own guard up.
In my opinion, I think that would be, assuming all the other elements are met, would be a violation. And probably an intentional tort as well, quite honestly, because they have knowledge that they're supposed to be having this guard. They unilaterally decided not to place the guard. The guard, is most likely required by the specific safety requirement. The only time you get out of a guard, not being required is when you have, again, the conveyor or something like that. The machinery, the manufacturer, the installer, all of them don't think that a guard is necessary. That's when you have that defense. But if you have someone coming in saying you should have a guard and you chose not to follow it, I'd be telling you as my client, I'd be telling, if you were my client, I'd be saying you have a serious issue here. You chose not to do this, and I think you're going to be looking at a violation, look into settlement. So
Yeah,
that's what my thoughts would be. Michael,
Yeah.
have you come across that? I mean, well, not have you come across that, I know you have. But what are your thoughts? How does that bode for the investigator?
Here's a couple scenarios that I've had that went different ways. If a piece of machinery falls under grandfathering and doesn't have, what would be considered additional guarding or safety device to it, and the employer abates that by adding it, they would not fall under what you normally would if a manufacturer gives you a piece of equipment that comes with all the manufacturer's safeguards and guarding and things like that. And you look at something, you go, well, I think that needs to be guarded. And the manufacturer going, well, no, not in our industry has tested this machine, and it according to our industry standards, along with regulations of OSHA and whatever state the regulatory are under, it doesn't need a guard. And you put one there that you shouldn't have, then you're going to have liability if you do that.
If the manufacturer or the installer comes in and says, this will be helpful and you choose not to, I think you're still gonna be liable, is what Michael's saying.
Yes.
But
Yeah.
if you put something on just unilaterally because you think it's gonna be helpful and it's not, it doesn't end up being industry standard. Michael, are you saying you think that they'll still be held liable as well?
Well, especially if it then alters that piece of equipment or machinery to where it could be more of a hazard than a help,
Mm-hmm.
and it doesn't meet safety standards. You put it up there, and then it fails. And that's something that the manufacturer didn't put on, or they recommended that you not put on. Generally, with any manufacturing equipment, they always have a caveat if there is something that is wrong with the machine, is to consult them first.
Mm-hmm.
Because then if you start working on it yourself, it voids the warranty of that equipment, and then they have no standing with any problem that would occur.
Okay, thank you.
Thank you, Michael.
Yes.
And so the last defense that we get to is the impossibility. The employer must show it would have been impossible to comply with the specific safety requirement, or that compliance would have precluded performance of the work, and no alternative means of employee protection existed or was available. And actually, this Jackson tube might be the one I was thinking of, Angela. Again, it's something else came out completely as regarding the operator, but I think this might be the overall case that I was thinking you could be involved in, but no, this was years ago. So, but again, it must show impossible, and that's really a last resort defense. I mean, this is one that everything's possible. Somebody can think outside the box, assuming it doesn't preclude performance of the work or put someone else in harm. It really, had to have been, let's say that safety backup alarm is that, that safety alarm was working, and the first time they backed up afterwards, there was nothing else, and then the question will be, was there alternative means of employee protection, and you go down that path. But the impossibility defense is one that is rarely used, quite honestly, or I should say rarely used successfully. All right, and then you get the other two doggies that live at my household just because you got through the defenses. They are actually sisters, litter mates, but they don't look a lot alike. But, all right, so the VSSR process. The VSSR process, you have the initial phase, which is the filing of the IC-89, the employer notification, and the employer answer. So the filing of the IC-89 is the first thing. That's the application that must be filed within the year of the date of injury. But for me, I always say that, the VSSR process begins much earlier than the filing of that IC-89. As soon as you know of an injury that could have a VSSR involved, the employer needs to be preparing their documentation. They need to gather all of their safety training. They need to, if there are witnesses, they need to make sure they have their contact information then, because they could walk off the job the next day. So it's those kind of things that are helpful to the client that can't be learned through the through the rules or the investigation or the checklist that is received, which we'll talk about here in a minute. So again, I believe that it's, educating clients, and I'm really happy to see that Michael is a VSSR safety consultant, because I have not come across a VSSR safety consultant prior to Michael. We see OSHA safety consultants, but we don't see VSSR safety consultants. So I think this is something great to take back to both of you, to take back to your attorneys and share that with your clients, as far as, okay, I've got an OSHA consultant, now I need a VSSR consultant, quite honestly, just to know the differences and just how to prepare. Like I said, the preparation phase happens before this IC89. If they understand that they have to be training and documenting that training and following up on that training and, constantly doing it. It's not just good enough that you had fall protection one time when they started 8 years ago. You need to be updating that annually, or every 6 months. There's things that an employer can do that will protect them before this VSSR process even begins. So you've got the IC89, you've got the employer notification, and then the answer. I don't know if Angela and Heather, either of you help prepare these answers or not, but a lot of times they're just very general. They're general in the sense of, we deny this, unless you have a legal position that you can take that would kick it out then, but usually it's just, we generally deny, and then everybody starts the process, because the investigation is going to happen no matter what. So you're just really getting that on the record that you deny it and moving on to the next piece. The post-investigation phase is the pre-hearing conference settlement. I put question mark to settlement and the SHO hearing. Really, you need to be talking about settlement much earlier than a pre-hearing conference. Now they are scheduling the pre-hearing conference and then scheduling the hearing, and there are no contingencies for a hearing. So unless you are already talking about it and know whether it's a possibility, you may end up going to hearing regardless, and we'll get to what happens there in a second. The appeal process is a request for rehearing or complaint in mandamus, which is how we get our case law, the 10th District and the Supreme Court cases that you guys see often. All right, so the initial phase we already talked about. The investigation phase, there's a 14-point checklist. Angela and Heather, have you guys seen these? Okay, and this is with the first interaction we would have with the BWC investigator. So I would learn Michael was assigned to this, and we would get this 14-point checklist. And then he would set up an inspection of the incident site, and he interviews all involved parties and witnesses, reviews the documentation submitted by the parties, and then a report of investigation is issued, and you have 30 days to supplement. This process takes roughly 60 to 90 days. I met with Fred Freeman. He's the director over there about a month or two ago, and they're down a few investigators, so it's taking a little bit longer, or at least that's what he says, but I actually don't think that. So I still think we're looking at, 30, 60 days when we see these reports. But the other piece, Michael, I saw you raised your hand. I'm going to get to you in 1 second. The other piece of preparing your clients is that 14-point checklist. I give that to my clients ahead of time, even if they don't have a VSSR. It's that part of that preparation package that you can share with them on that they know about VSSRs, and that if they have a claim that looks like it could be a VSSR, prepare that 14-point checklist then. That way they know that they are keeping that information. Michael, go ahead.
Oh, I was just going to mention about the turnaround on investigations, because when I retired, other than Fred and Karen, who's up in the Cleveland area, those are the two most experienced people with VSSRs. And when I retired, I was also one of the senior investigators. And probably within a month, they were down to 4 investigators for the entire state.
Yeah.
Trying to fill positions, and they're just now getting, I don't think they've filled the Columbus slot as of yet, I don't think, I've been talking to Fred and you know, he's been having to train all the new people, and usually with one thing about VSSR investigations, it takes you a good year and a half to really get in tune to how to operate an investigation and working with both parties and any other entities that you have to do. So that experience is what really hurts them because, you know, I'd been there forever. And I also did all the high profile death investigations. So when I left, there was really no one other than Fred that would do that.
Yeah, I would agree with that. And I think you can see, I hope I put it on the right screen. Do you see a map of Ohio?
Yes.
So this is a presentation I did with Fred at the Ohio Safety Congress, and this was the last I knew as far as who was covering where. So you can see that these, and exactly as Michael was saying, that, you know, other than Karen and Fred, and Nathan has been there a little bit too, but you know, they're pretty much newer, but these areas are who the investigators are assigned to. So, you know, if you've got something in Tuscarawas County, you're going to work with Gina Shalomel, you know, those kind of things. So this was a slide, like I said, from there. So I didn't include it in my slides because technically it's the Bureau slide, so I didn't want to steal it. But since we're just, you know, since we were talking about this, I did want to share it. So I won't say anything if you screenshot it. It was public as soon as it became, as soon as it came out from the Safety Congress. But I just thought as we were talking about it, we wanted to share. I do think that orange spot that was vacant before, I think they may have gotten that covered.
Yes.
Yeah, that's what I was trying to remember who it is, but I'm not sure. So yeah, now they're down to one, like Michael said, in Columbus, which is that teal area. But yeah, I mean, they're getting better and they're getting more up to speed, but I think they're doing good on time as far as you know, the reports and things still. So, all right, I'm gonna get back to, there we go. So the investigation phase, like I said, you know, in preparing your clients earlier, I recommend putting out that 14-point checklist earlier, just letting your clients know what they're looking for when you're training them for VSSRs. After you get the report of investigation, which is fact-based, it's only what the investigator finds. Factually, they're not putting their spin on it. They're not putting their thoughts on it as to whether there's a violation. They're just giving the facts from both sides in the report so everybody has it. If you feel like something needs clarified or you know, added, then you have 30 days to supplement by statute. So you've got that as well. All right, so post-investigation phase, you have a pre-hearing conference where they'll schedule the merit hearing. They'll ask if any witnesses need subpoena, different things like that. It is just a hearing for the attorneys and the hearing officer. Clients are not present. They're all done by phone now or WebEx, and so they're pretty quickly and just kind of a pre-trial conference, for lack of better words. Like I said, if you're talking about settlement, you at least want to have that conversation with opposing counsel prior to the pre-hearing conference. It could be just a week prior, but as long as you're both on the same page, then you know how to schedule that merit hearing. Are you looking at 30 days or are you looking at 60 days? Or, you know, are you looking at 90 days? If you know that you're going to be negotiating, you're going to give yourself a little bit more time there. So if someone says no way, settlement's off the table, you may as well just get it done quickly and get it over with, you know, so rather than draw it out. And then you have that SHO hearing before the Industrial Commission, which is the merit hearing. And that's where, you know, there's heavy preparation, witnesses that come in. And if you've not attended one of those, I do encourage you to attend them just to see how they go. You know, I mean, it's a different type of hearing. It's, you know, there's usually a court reporter there, so it's a little bit more formal. But, you know, I just think that those are good to see. Appeal process, you can request a rehearing or you can file a complaint in mandamus. That the request for rehearing, it's you know, it's kind of done as a formality. We sometimes see the hearings. As you guys know, industrial commission full hearings are rarely granted, and it's the same here. So that's where we see the complaints and mandamus filed. And so either the employer or the claimant can file those, whoever came out on the wrong side of the order. And then that's where there's oral arguments before the 10th district and sometimes goes up to the Supreme Court. But that's really where we get our laws on VSSR. We've got these basic statutes, but all the nuances come from the case law. All right, so I think I must have taken my examples out because I was just planning on going through them throughout. But we are at 1 o'clock, so at least want to share some time for questions or anything. Heather, Angela, Michael, any questions or anything that's going on that you want to discuss?
No, I don't. I think you were very thorough. It's always good to, personally, I don't get my hands on that many VSSRs. So anytime there's a refresher even, I think it's good to get that in front of me. And I've been doing this for 29 years. So, and Heather's not too far behind me in years of experience, I don't think.
And that's what I think too. I think, I don't know all the code sections. Michael may know all the code section because that was his everyday, but I know them when I need to. And I know all the other pieces around it, but, to know every single code section, is impossible. But if we know the industries that we're in, that's half the battle.
Yeah, and I'm going to put my email address in the chat.
Okay.
And Michael, I can't talk and write at the same time. .com. Michael, if you would like to take down that email address and provide me with any information regarding your consulting business, I will be happy to pass that along to my attorneys and see if there is any interest there for any kind of interaction. And at least I can give you an introduction.
Well, thank you. Yeah, that would be helpful. And one of the things that I always used to advise employers, because they would call us and they say, "Hey, can you?" We would do safety talks and stuff like that for employees and employers. But one of the things that I always encourage employers, if they had something that they felt they needed to address or have a piece of equipment reviewed, is to contact the safety and hygiene department, and they would come out, of course, and look over the equipment and do a summary, and then give you some options on if it needs guarding or you need more training or whatever it is that you would need if you have any safety issues, or if you already have a safety program, how to enhance it with, because a lot of people don't keep up with new updates with manufacturing or coding and things like that, and they can help you quite a bit.
Yeah, that's a good idea too. Thank you.
Mm-hmm.
And Heather and Angela, to the extent I know you both work with wonderful attorneys and they've been doing VSSR a long time. I know who you both work, not maybe specifically who you work with, but I know your firms. But to the extent that you guys have a question as you're going through something, I'm a resource to you as well, just to say, hey, can I bounce something off you? You're like, I don't want to go to the attorney yet. Feel free to call me. I'm happy to.
Thank you.
Yeah.
I appreciate that. And if you aren't opposed to sharing your slides with me, I'll circulate those to Heather. I do not circulate slides to anyone who was not in attendance.
Okay.
So it would only be for the benefit of those who are here present this afternoon.
Okay, happy to share those. So I'll send those to you and then let you circulate.
Okay, thank you.
All right.
Thank you.
Sure.
And Sue, we may well ask you to come back. This is a topic that, and I think it's the month of May. There's a lot of things going on with the Paralegal Association, and it's a busy time. And I think that is why we had so few people join us today. So maybe a better timed presentation might be of benefit.
No worries, no
But
worries.
thank you so much for being with us and sharing your time and expertise.
Happy to help, and if you need anything, just let me know.
Okay, great. Thanks so much.
See ya. Bye.
Bye-bye.